Won't you pardon me, pretty woman? I couldn't help but see, pretty woman, walking down the street, pretty woman, the kind I'd like to meet.
Hi Kanika, how are you doing?
Hi Rajan, I'm doing well. How about yourself?
Pretty woman.
Thank you.
Kanika, for nuts, you don't look like an arbitration lawyer.
Okay.
Just an okay?
I mean, I've received that
was
before.
a compliment.
Thank you so much.
And
you started off my midweek very well.
yeah, and do really judges in high courts and Supreme Courts get intimidated by good-looking women lawyers?
No, I don't think
That's
so.
a common observation.
I think it's more of a stigma than an observation. I think it's all kinds of stories that make their way through the corridors of the court. Yes, it's very rare to see women in courts anyway, and that's a given for every state across the country. But we do have some very good-looking women who are appearing before judges.
Does that tilt the case any which ways, this way or that way? When a case is getting represented by a pretty woman like you? Has it happened with you?
No, I don't think so. I think we're past that stage. Yes, there was a phase where we would see a lot of gender bias going on, but I think things are getting better now.
Which phase was that?
I'm very happy to say I was not a part of that phase, but we've also heard stories of the same.
Arbitration lawyers are stinking rich. I mean, do you actually make more money than a regular high court lawyer?
It's actually the other way around. I think high court counsels.
I can see those gorgeous diamond jewelry. I mean,
well, I've recently gotten married, so the credit goes to dear husband.
so do you actually make more money than?
I think to be very
practicing-
candid,
Yeah.
lawyers generally make good money, but I don't think it's the case from day one.
Is arbitration more paying than regular practice in, say, high court?
I think arbitration is more well-paying from an earlier age in the profession compared to the same in court, only because arbitration is restricted to massive commercial contracts generally, which are higher stakes and
therefore more paying.
Yeah, therefore more paying.
Is that why you chose arbitration?
No, I think I don't think that's the reason I chose arbitration to begin with. I did specialize in infrastructure and disputes right from the beginning of my career because my former boss specialized in the same. And 99% of infrastructure disputes go into arbitration, so we're bound to do arbitrations.
I believe you studied law because you were poor in maths.
Yeah.
Am I right?
That's right.
Both law and maths require the same mindset of good logic. But what is the difference? How is a good lawyer different from a mathematician?
80% of the lawyers that I've come across are all poor in math. I think it's a general DNA trait that we all have. We're horrible with math. I think the logical part of the profession, whether it is mathematics or law, is very, very different. I think it's not about the logic that we have a problem with, because that's a part and parcel of the role that we have. I think it's just a phobia of numbers, to be honest. I see numbers and I start sweating. I don't like numbers very much.
Infrastructure dispute, I mean, that's what you kind of picked up. And it's a very, I would say, uncommon domain yet in India. Why would there be infrastructure disputes in the first place when on one side there's government, which ought to be a neutral body, and there are large corporates as contractors for, these are not small time companies building residential houses. People who build, companies who build bridges and dams and flyovers, they are large corporates, right? They are well regulated. Many of them are listed in the stock market. So why would there be a dispute between the government and organized companies?
I don't think infrastructure and construction disputes is a newer market of disputes that has emerged. I think it's always been around, not just in India, but globally. There is not a single infrastructure project or a construction project which would get completed without a dispute. And that is because, again, large monies are at stake. It's a technical project to be carried out. There are variations that take place, there are additional costs that are being incurred, delays that happen, delays within your control, delays outside your control. And I think at the end of the project, when there's an X sum of money that is due and pending because of this extra scope of work or the delays or the variations or anything for that matter, the dispute is all about that is it attributable to the contractor or is it attributable to the employer? And that is what an arbitration.
What I'm trying to figure out is why should there be a dispute between government, which is a fair player? What do we, when we refer to government as an entity, a man in the street, we think that our government would never do bad to us. The government doesn't have self-interest. So why would there be a dispute between government and large corporates which are regulated by market laws?
So I think fair play is a very subjective terminology over here. Most of the government contracts, especially for the infrastructure sector, are all very watertight and very one-sided. They don't allow a lot of scope for the contractors to claim what they're rightfully entitled to. For example, a number of these contracts allow the employer to terminate the contract unilaterally on a few broad-ended conditions being met, which are generally very unfair to the contractor. We talk about arbitrations, for example. Appointment of an arbitrator is supposed to be a very neutral, the arbitrator is supposed to be a neutral entity which is appointed to adjudicate the dispute.
And most aren't.
No, that was the case before 2019, 2018. The court did take cognizance of that because earlier these infrastructure contracts would say, hey, we have a dispute, fine, you want to appoint an arbitrator, please choose one from a panel of 3 or 4 arbitrators that are primarily
chosen by the government.
Yeah, which are primarily retired officers of the government. How the hell are they going to be neutral? That's not a possibility. Now the courts have passed judgments where they said that yes, that is completely bad in law, you can't be choosing an arbitrator this way. And you can always go to the court for an appointment of arbitrator, even if the clause in the contract states otherwise. Irrespective of having these judgments passed, irrespective of
the government still goes ahead and appoints their own arbitrators.
No, they don't appoint them.
Let's come back to the
clauses.
Yeah, let's come back to the point. You're saying that, in essence, it means that the government is not a fair player.
I think when it comes to commercial contracts, I don't think anybody is a fair player.
So whose interest is the government peddling to? The government is an entity, not an individual. So why would the government be one-sided? There is no personal interest with any government decision making.
No, not at all. There's no personal interest.
What is why should there be disputes with the government?
See, I think it's a very simple scenario. When you get into any kind of transaction with anyone, which is completely commercial in nature, you look after your interests and you safeguard your interests, and I will look after my interests and safeguard my interests.
So who is this my in government?
The contractor and the employer. Completely, hear me out. They're trying to build a project, say a highway between 2 tier 2, tier 3 cities, and they're trying to give out this project at the lowest rate, and the lowest bidder obviously wins the project. Once they do, they obviously don't want the contractor to be in a position where they start extorting money from the government, which I think is fair. And I think increasingly the newer PSUs and public sector undertakings that you have in India are a lot more progressive this way. Fine, the contract doesn't allow for these extra claims to be claimed, but if you provide me logic and if you provide me the right paper trail, and the law anyway is equitable enough to be allowing a remedy which is fair and just, we're okay to give that off. We're okay to settle the matter as well without going into arbitration. I think now the government PSUs are kind of coming to an idea where there are certain things that are not in your control when you're carrying out the project. For example, you had the COVID-19 pandemic. There was a delay. Work had stopped. There was idling of resources that took place. You had the Russia-Ukraine war. In the price of input commodities escalated very, very steeply. It was completely unforeseeable for contractors to have thought that the prices of steel would shoot up because of some event.
But
so
these
there's an extra
clauses,
cost.
these clauses are any which ways vetted by the contractors, agreed upon that if there is an escalation, the government would offset them for that.
Okay, let me just set the record right. These contracts, any infrastructure, construction dispute contracts, a tender which is released by the government is completely drafted by the government. So it very well will prioritize the interests of the government more than the interests of the contractor. And that is the case even till today, for that matter. Everybody knows that, when you're signing an infrastructure project, or if you're, if your bid has been accepted by a certain PSU, you're going to carry on with the projects, but there are going to be issues that you'll have to, get adjudicated by the arbitrator. There's going to be no other way of doing it.
Is this the bureaucracy in between which is playing the spoil sport?
Not at all. Not at all.
Is the Indian bureaucracy fair?
I think it is. I think it is. I think.
So who are unfair? The politicians?
I don't think anybody is unfair over here. I think it's just the way the trade goes on. Specifically talking about the topic that we are on, I don't think anyone is trying to play unfair. It's more about the fact that there are two entities. There's a state and there's a private player, and they're trying to get a project done together. The state entity is paying you the money to do it, and you're the one who's doing it and cutting your cut of the profit out of it. And then there are these events that take place during the performance of the contract. Well, somebody's got to pay for them. The private player says that you pay for it because these events are attributable to you, and the state says, not my problem, you bear the cost of it.
I'm given to believe that a lot of these cases are settled out of the court, under the table, with whosoever, right? And the lawyers mint a lot of money out of settling cases. Be fair to me with that answer. Yes, no.
There are two sides to this. Number one, lawyers make money for all kinds of professional services given. And if a matter gets settled, we are obliged to get our fees because we worked on the matter. As far as the malpractices are concerned, yes, the corruption rate was quite high a couple of years ago. Ever since 2014, you're seeing that the malpractices ratio in India has drastically decreased.
All right, but in lieu of what I asked you, look at the number of construction companies who had bought electoral bonds. What were they for?
Well, you should be asking them that. I wouldn't
All right.
know.
If I was your client and I told you, hey, settle this, my cost of fighting this case is perhaps lesser than settling the case.
Yeah.
You would have to have an avenue to settle it for me.
Right.
What is that avenue? How would you settle it? You can't dial up the government and say settle it. So what's that recourse?
Well, it's more than often that we are asked to settle matters because I think arbitration is a 5-year marriage that nobody wants to be a part of unless there is no other way of doing it. But doing settlement is generally not doing undertabling. Let me be very precise over here. Settlement is, generally more than half of the contracts allow for settlement. It's called conciliation, actually. And either way, there is, in a PSU that I'm dealing with as the employer of the contract, there are certain people who are in charge of a certain project over there, and we give a call to them and say that, look, we've raised this
Now, who
notice.
calls whom?
We call the government PSU, the lawyers do, or even the client can.
So is it always between lawyer of one side and the other, talking between them for a settlement?
I think it depends from client to client. If a client is comfortable to have that conversation without the lawyers, then they can. If they want the lawyers to be there, then we're happy to be there.
As a professional law firm owner, founder, what do you prefer? To settle an arbitration or to fight an arbitration to the end?
Settle. Any day.
Something I'm very curious to understand in your profession. You speak fine English, lived in Dubai, worked and studied in London. If you are someone who came from the backyard college of India, not being able to speak fine English, could you still be an arbitration lawyer for the construction industry? How important is English language to succeed?
I think law as a profession depends a lot on your vocabulary and your verbal skills. It doesn't matter what language you're using, because you do have courts that are still listening to matters in the vernacular language of that particular state. But as you move up the ladder, arbitrations generally, especially in our sector, are conducted in English. The drafting of pleadings is done in English. So you have to have finesse and command over the language.
So at the end of the day, you have two attributes to intimidate the arbitrator: your looks and your language skills. Am I right?
I don't think they are intimidated by the looks at all. But the language, I think, is just a part and parcel of the skill set that you're supposed to have. And without it, and even if, I don't think you can actually categorize somebody who studied in London and somebody who's coming from a tier 2, tier 3 city in India. I think I've come across many people who've come from tier 2, tier 3 cities and have excellent command on the language.
Do you read enough?
I love reading, actually.
I'm talking about legal reading, or you leave it to your juniors to suggest, make files for you?
No, I do read all the documents that I get. Yes, I don't deep dive the way they do, and huge credit goes to them.
Deep diving is one aspect that is missing with the lawyers your age, where people like you hire a lot of juniors and don't read up themselves. It's a drawback?
Yes, that is a drawback. I think a lot of a lot of lawyers face the wrath of clients because of not knowing what the matter is about. When I was working for other firms, apart from Hero Advani's firm, because I think that's an excellent place to learn as a lawyer. But a number of other lawyers that I've worked with have actually faced the wrath of clients as well as judges because they did not read what the matter is about, and then it adds up to the anxiety level and you're sitting anxiously waiting for the court to pronounce their orders. That's not the right way of doing it. I think a proper system needs to be in place, a proper delegation map needs to be in place, who's doing what, and the entire team, including the partner in charge of the particular mandate, needs to be completely briefed on what's where, what are the issues, what's the outcome going to look like.
So what we see today with lawyers of your generation, vis-a-vis the previous generation, is that you guys take up a lot of cases. It's more of the movie stars of the 80s, where they're working multiple shifts, quick bucks, because they know that their lifespan is short. Right? So you guys take up a lot of cases, set up a firm, and delegate the reading bit to your juniors. Is this the right way forward?
No, it's absolutely not the right way. I think when you're running a law firm, you have to be very mindful about how much of a bandwidth you are carrying, financially, resource-wise, time-wise, because these are all lengthy, time-consuming matters. I think it's safe to say that you can't bake too many cakes and then there aren't enough ingredients to be baking them and you've just taken up orders. That's not how it works. I think the way we run is that we have handpicked our resources very carefully. That's
Infrastructure disputes require in-depth technical knowledge, in most cases, civil engineering knowledge. So how does a person like you, without a civil engineering background and with no partner who has a civil engineering background, how do you build up these cases?
As you go along the process, it kind of, your mind grasps these concepts that are very familiar to all infrastructure projects. But till today, I think the first step for any case for me is to sit down with the projects team and understand what the case is about, technically what were we supposed to do, what actually happened, what were the loopholes. And our agenda, I'm not here to be an engineer. I don't think any lawyer is here to be an engineer. We're only here to legally substantiate what your technical claims are. That's our role.
Yeah, but Kanika, I understand that on the other side, which is the government, they would be far more prepared with with people on their panel who are technical experts, civil engineers, to fight a case against your contractors. Their lawyers would be supported by civil engineers, but still they lose the cases. You may not be in a position to hire an expensive civil engineer to kind of give you the intellectual or the knowledge support to fight a case. They would be. But despite that, why do they lose cases?
I think it's the complete opposite, actually. Generally, the private players and the contractors are far more equipped when it comes to an arbitration or a legal battle than the government lawyers or the government PSUs rather. And that is primarily and only because the contractors invest in their resources and the government PSUs don't. Now that they have started, in the last 2 years, I've seen a change in how they've approached matters, but otherwise it was always the contractors investing well. So what does it take to build the right team? It takes an arguing counsel who can argue your matters well. It takes advocates on records who are drafting your pleadings well, which is us in most cases. You require a claim consultant who's going to quantify your damages, delay as well as quantum. And you require a good team of your in-house people to sit with us and explain everything. You will always see this battalion of a team from the contractor's side, but you would never see the same kind of investment done on the government side. And this was prima facie the reason why they were losing arbitrations. Now, if you see, the government has started doing exactly what the private players do. They've started giving matters to specialized lawyers. They've started getting claim consultants onboarded. They've, initially what used to happen is you get empaneled with them, you're not getting paid well enough. So a lot of law firms would refuse to take that kind of work. Their budget would never allow a claim consultant to be appointed.
I understand that's one reason why for so long you had been working for contractors and not with the government. Now that the scenario has changed, would you like to switch sides and work with the government?
I have switched sides.
Oh, you have started working with the government?
I do work for the government, but I'm not empaneled with anyone. I work with them on project basis. But that would still be like 10 to 15% of the work that we do. A larger crux is still with the
And what is the
players.
difference between working with the government and working with a contractor?
I think working with a contractor is far more streamlined. There are things that we need when you're working on a matter, whether it is a proper paper trail of documentation that we need to use to substantiate the claims. I think the contractor generally has their resources in place. There's not much justification that I need to give to the contractor if a few extra bucks have to be spent on certain resources to be acquired. I think with the government, again, there are two categories of organizations. One would be the older organizations that would still work on the conventional way of working, having their sarkari lawyers and their sarkari means of doing work. I think it's a very laid back approach. But the newer government organizations that have emerged with thanks to the new government, I think they're very progressive in nature.
Kanika, the new fad in the legal fraternity is to open up a law firm, and even if they haven't, just a couple of members, they're calling themselves law firms. what is a law firm? Now, this concept is a new import to India. Up until 15 years back, there were very few law firms in the truest sense. What, according to you, should be the connotation of a law firm?
You're absolutely right when you said that this is not a very deep-rooted concept in India. I wouldn't say about India. I think generally the profession of an advocate is that of a lone wolf. And a lot of lawyers practice individually, practice with limited bandwidth, with limited time that they can give, and with limited clients that they take up. A law firm is a team of lawyers coming in together to provide assistance on matters that involve higher stakes. Getting a team together of, say about 5 to 6 lawyers that are from different areas of specialization, if required, or from the same area of specialization, with different years of experience, kind of makes a workflow take place in a certain office, which means that you're in a position to take up more work, you're in a position to perform the work better, because I think 5 minds work better than
Appreciate,
one.
but why would 5 people who are equally qualified as you are join hands with you and work under you?
I think with the profession, there's a bit of a DNA trait again, which is that of learning. Law as a profession is, you see success at a much later stage, after you've gained enough experience, which is why it's called the practice of law. You have to practice on many cases to become an expert of that subject matter.
But we see that getting lawyers together under one roof to make a law firm is a very difficult task. How do you plan to do that?
Yes, I think the trend is becoming more and more common, especially in Delhi, if I have to compare it with any other metropolitan city in India. So if I go about 10 to 15 years back in history, there was a sudden surge of these massive law firms that made an entry in the India market, trying to get the more westernized culture of law firm into India. Now the problem with that, it seemed very shiny and glossy. It still is, if you ask me. But with no offense to anyone, a lot of specialization got diluted. And the clients were not very happy because they took up this exorbitant amount of work on their shoulders, but they were not able to cater to every client the way the client required. When you talk about getting a client on board, I think a lawyer-client relationship is very similar to a doctor-patient relationship. It's a fiduciary relationship. And you need to be able to give that amount of attention to a client. And if you don't, the client is not happy with the service that you've given. And we've had clients where we have seen clients work with bigger setups, non-specialized setups, burnt their fingers by putting in a very high amount of fees into a certain mandate, and they were not very happy at the end of the day. However, I wanted to, and I wouldn't say I think we, because I think we have a very good team in place now. We wanted to provide a place which was, one, specialized, so we're not looking at anything except construction and infrastructure over here. Second, we wanted to give each and every client the attention that they require.
I appreciate, but law firms have over the years become very evolved, where they have put in place a system of acquiring clients which individual lawyers or the smaller firms like you find it difficult to do. So a lot of companies prefer a law firm because they bring that bandwidth of knowledge which is extremely valuable. So we find that good talents are actually preferring to work under large banners, if I may call them, than with individual lawyers.
I would actually disagree with that. I think the top 10 infrastructure companies that I've had this discussion with in India are actually not looking to work with bigger setups, because they know that when they go to a bigger setup, they're just one of the 100 clients that the law firm has. And they know they've had this experience, but they've not been very happy with the kind of service they receive. It is a service industry at the end of the day. And they consciously say that we want to work with smaller setups, we want to work with specialized setups, because we know the quality of work that is going to be churned out of that place. Because our mandate means a lot to that law firm, and our work is going to be of priority over there.
I was speaking to the outgoing president of Supreme Court Bar Association, Adesh Agarwala, last week, and he says that there is this big movement, I don't know, right or wrong, big divide rather, between elite lawyers and mass lawyers. How true is it? Is there really a divide between elite and mass lawyers?
I think there's a very high degree of nepotism in the industry. I think most of the mass lawyers would agree to that. I don't come from, I'm a first generation lawyer, I don't come from a lawyer background. And I think that it is much harder for somebody who is a first generation lawyer to climb up the ladder than, for someone who's had a backing of a legal officer in the house. We see that in courts all the time. We see that in social circles all the time. But I think it is a part and parcel of the industry that I don't think that we can complain about it, but we can't change it.
So who is an elite lawyer in simple terms?
Second, third, fourth generation lawyers.
And how do they dominate the industry?
I think it's
I'm sorry, industry is not the right word, but how do they dominate the fraternity?
I don't think they're dominating at all. I don't think so. I think they have a soft launch into the market, but gone is the time when clients were not aware. So there was a time when clients would come to lawyers and they wouldn't know the intricacies or the legalities of what was happening, and they would simply leave it to the lawyer to decide. Things have changed now. Companies and general counsels of companies and even engineers of companies who you're dealing with know the law very well. So they will smell the crap before you know it. It's not easy to fool them.
Let's take an example. You started it all afresh, without a backing, as you said. I could be somebody's son who is inheriting a legacy, right? Why would a client trust you vis-a-vis me?
I think from a generalist perspective, a natural choice without having a conversation would be somebody who's had that kind of backing. It's very obvious. And I don't blame them for doing that. But I've seen clients who've made that very natural choice and burnt their fingers. And it always takes one assignment to know if a certain lawyer or a certain individual can do the job or not.
So there are these specific law colleges. It's like the ticket to heaven. If you've got an admission to those law colleges, you're there, that's with all colleges. All domains of education, rather. In engineering, it's an IIT or a couple of IIMs, Does it really work that way? Is it that the top-notch law colleges give you better education than smaller law colleges?
There is definitely a preference for the national law colleges, or if you're in Bombay, then the GLC of Bombay, and whatever products are being graduated from there are definitely given some kind of leverage in hiring.
But as an entrepreneur now, I mean, as a founder of a law firm, what kind of criteria do you set for people who you are hiring?
I don't think for me degrees matter too much.
So what matters?
Your experience that you've had, the kind of
I'm a fresher.
knowledge. The kind of knowledge and sincerity that you have shown.
How do you measure sincerity?
Even if you're a fresher,
how do you
doesn't
measure
mean.
sincerity? When you're hiring me, how do you measure sincerity?
So I normally don't hire right away. I normally get them as a trainee first and then make them climb up the ladder. I need to see if you are right for the organization, if you're healthy for the organization. If you
How
can
much do you pay a trainee?
We pay them enough, and I think more than the other competitors that we have in the industry. I don't like free labor.
All right. We see Indian corporates not investing in dispute legal consultancy, which is a very common practice overseas. Worldwide, companies abstain themselves from getting into litigations and try to stem the source of litigation. In India, apart from the top 200 BSE, NSE, Bombay Stock Exchange listed companies, if I may say so, other corporates who are big, but they think it's a waste of money to spend on lawyers for consultancy to stave off from disputes.
You're absolutely right in this. We normally get a call when the house is already on fire, and then there's only limited options available to us.
But you make more money out of that.
But I'll tell you, well, that's a different story. But I'll tell you, there is a difference that I'm seeing in the market today, very interestingly. I think the companies in tier 2 and tier 3 cities are actually investing in this more than the BSE top 100, top 200. That is because they have now realized that it's better to be safe than sorry. The bigger companies have deep enough pockets to go into litigation, to go into disputes, to do an arbitration. For them, it's a part and parcel of companies' revenue or companies' operations. The tier 2, tier 3 companies are far more aware of procedures where they want to invest enough in resources so that they can avoid that 5-year legal battle completely. For me personally, I absolutely love working with companies in tier 2, tier 3 cities than the metropolitan cities.
Are they more friendlier? The promoters?
I don't think the criteria is them being friendly. I think the criteria is just that they are more streamlined and they are more sincere to work with.
What is this great desire to be represented by a branded law firm?
Well, it's a very human trait, to be honest. When you want to buy a car, everyone would say that we want a Mercedes or we want an Audi, not realizing that jitni maintenance problem wo gaadi degi, a Toyota and a Honda probably would not. And I'm not saying that all the bigger law firms are not doing good enough work. I think they are. I think it depends from client to client what they're looking for and what the requirements are.
Kanika, are you a lawyer with a face value yet?
I think in the industry, yes. In the infrastructure and construction industry, yes. But I don't think I'm anywhere close to what I personally aspire to be.
I love that bit. You're unabashedly proud woman.
Well, I
Well,
get it.
you don't care a hoots about saying that, where I am a face value. Most of the lawyers that I speak to, they pretend to be someone who is not comfortable with this proposition of face value.
I think there's a difference between attitude and gratitude. I'm not carrying an attitude about it, but am I ever grateful for it? Yes.
How much do face value lawyers overcharge?
There's no percentage as such. I think the better face value that you have, I think, see, at the end of the day, the clients are putting a lot of risk into these matters. And it's just easier to take that risk with somebody that carries the experience or, has some references.
So what is face value? Face value isn't experience. Face value is something else.
No. Face value is completely experience.
Face value is standing in front of a judge or an arbitrator in your case who respects the face that you are and is somewhat, cautious. That, okay, this person is representing this case, so I better be careful with my judgment.
I think that's a very narrow way of defining face value, first of all. I think face value is also about word of mouth, that clients have been very happy with the kind of services that they've received. When we take up a matter, I take up responsibility for it, and I'm accountable for it if something goes wrong.
Okay, coming back to arbitration, Justice Abhay Oka in Supreme Court last week made a sweeping comment about the arbitration process. With a lot of fanfare, arbitration was introduced in the year 1996 in India to lessen the burden of courts. Justice Abhay says that the arbitration process, the way it has evolved over the last 20 years, hasn't really helped that cause. Long delays in arbitration, arbitration becoming very expensive, reconciliation not happening, people resorting to Section 34C to challenge arbitrations instead of reconciliation happening. The cases are anyway getting back to the courts.
Is it a big problem? Yes. The big problem is because it's easy access to go and challenge the award in courts. But
do you agree with Justice Abhay Oka?
I do. I think this is a problem that every disputes lawyer would agree to, quite frankly. It's one, the access to courts is very easy, but you have to bear one thing in mind, that it takes time to evolve into a stable framework. India is a very, very new jurisdiction when it comes to arbitration. I think it's going through ups and downs and evolutions by every passing judgment. Each and every part is scrutinized. Each and every part is changing with time. And again, this is going to take the time that it demands. But are we moving in the right direction? Yes.
But Kanika, do you think that arbitration process should be less of battles as we witness in the court, battles of egos, battles of logic, and more of reconciliation, more of two parties coming together outside the court in more familiar environment and settling across the table, and the lawyers probably assisting them to settle?
No, absolutely. I think contracts anyway provide for that. Dispute resolution clauses in contracts are morally layered. So the first one or two steps are always about conciliation and amicably resolving the dispute. If it doesn't get resolved, one doesn't have a choice but to enter into arbitration, and then whatever the act says and whatever procedures are applicable.
But arbitration process could also be a reconciliation process between two parties.
I don't think so. I think arbitration is legally binding, reconciliation is not. And sometimes there's no room for reconciliation. There's no, one party may be interested, but the other is not. And that is pretty much the reason why people go into arbitration. Most of the arbitrations, that's not the first step that a contractor or a government PSU takes. I think it's after amicable settlements have failed, or it's after reconciliation proceedings have failed, when you have no other choice. Either you let your claim die out, or you go and claim for it in an arbitration. And sometimes the claim amount is quite high for it to, die out. I don't think anybody can afford that.
What kind of claims are you dealing with generally? What is the nature of these claims?
I'm a Fessi, 85% of all construction infrastructure arbitrations are quite similar in terms of the causes of action. So we're talking about delays of work in performance. We're talking about additional costs that are being incurred, outside the contract price that has already been agreed upon. We're talking about technical variations, that an X amount of work was supposed to be done, as per these so-and-so technical specifications, but these specifications were then changed. Who is going to factor in that into the cost that we have incurred? Or it may be just unforeseeable events that have had an impact on the project.
Pretty often we are seeing in arbitration, instead of former retired judges, we have lawyers, and that to junior or mid-level lawyers, taking up the mantle of being a judge, as in the arbitration process. How fair is it? Why would be a lawyer be treated as a judge?
So I think it is absolutely fair, number one. Number two, this practice of having honorable retired judges as arbitrators,
which is okay,
but is why restricted to only in India. It doesn't happen outside India.
Okay.
Outside India, say if there's a matter which has a panel of 3 arbitrators, one may be ex-judiciary, one may be a technical engineer who would understand the technical aspects of the contract, one may be a bureaucrat, a retired bureaucrat, or a retired project director of some company. The beauty of arbitration is that you can choose who you want to adjudicate the matter. Many a times, of course, former judiciary that we have in the country are excellent adjudicators because they've been conditioned to be so. And generally that is a natural choice for the bigger companies. But if it's a smaller mandate, if it is something that you may not require a former judiciary member to be an arbitrator, you're more than welcome to choose whoever you like for that
But to
matter.
become a judge, you need to be a person who is neutral in mind.
Of course.
He's tempered to be neutral. He's educated to be neutral. He's trained to be neutral. But a lawyer appointed by one of the parties is never neutral.
So it's never, so an arbitration is an odd number of arbitrators that you have. You either have 1 or you have 3 generally. When you have 1, that person is appointed by both parties by mutual consent, knowing very well that that entity is going to be a neutral, unbiased entity. It doesn't matter whether they were a retired judge, whether they are a retired project director, whether they are a lawyer, it doesn't matter. 2 parties are at complete flexibility and have the autonomy to choose who they like to adjudicate the dispute. But of course, when you talk about the Indian market of arbitration, there is a practice of getting retired judges because we know that they carry the experience to adjudicate matters. We know that they have the required expertise to do so. And that is, I think, completely up to party autonomy as to who they want.
Have you come across cases where arbitrators has been paid off by one or the other party for a favorable judgment?
No.
Does it happen?
Not that I'm aware of. Not that I'm aware of.
How do you deal with unfair judgments in arbitration? Do you go for an appeal?
Yeah, I mean, I think it's a very natural next step to take. If if an order, if the arbitral award is not passed in your favor, I think it's a general practice to file a Section 34 and challenge the award. That's a given. That's just part of the process. Because again, as I said earlier, it's easy access to courts. I think the courts should probably think about restricting this access, so that the effect of that arbitral award or the weight that it carries is a lot more.
Vikas, what are you serving us?
So, sir, I'm gonna serve you Americano and cappuccino.
I believe Belly's coffee is pretty famous in Gurgaon.
Yes, sir, because I have done my brewing before joining Bailey's.
Great. Black coffee for me.
Sure.
What about you?
I'll have an iced black actually, or cappuccino, whatever.
Done.
Works.
I'll get you cappuccino.
Thank you.
Kanika, ये Bombay Delhi का क्या divide है? You know, I hear from my lawyer friends that the Bombay lawyers are professional and the Delhi lawyers aren't. अब मैंने उसको पूछना भाई professional का मतलब क्या है उन लोगों को? They say that Bombay lawyers don't overcharge you, don't drag a case. Delhi lawyers.
I think divide बहुत ज़्यादा deep है. If you ask me, ये छोटा divide नहीं है. ये in fact it's not even specific to the fraternity. ये काफी ज़्यादा.
And you've worked in both cities.
I've worked in both.
You
cities.
started in Bombay, then
Yes.
moved to Delhi.
Yes, and I personally, if you ask me, it's not about the profession as much. I still prefer Bombay people over Delhi people. Delhi is like कर लेंगे, देख लेंगे, हो जाएगा, कल हो जाएगा, परसों भी हो जाएगा, अगले महीने देख लेंगे. I don't like that approach. But I think Delhi people and Bombay people have this great war going on, which is beyond the professions, beyond any kind of likes and dislikes. It's just that they're completely different worlds.
But the Supreme Court is in Delhi, so that's a huge advantage to people who are practicing in Delhi.
Yeah,
Law firms who are headquartered here.
See, it is the epicenter of litigation. You know, keeping all your personal likes and dislikes aside, it is the epicenter of litigation.
Kanika, you know, I have a lot of friends from the legal fraternity. So one thing that I come across is that most of them, people in police and law, are people with very suspicious nature.
Oh, is it?
Lawyers हर किसी को suspect करता है जैसे पुलिस करते हैं. Oh, and that's inbuilt in their nature. Am I right?
I think we're analytical. I agree with you, but I think it's a bit overhyped as well. I think there's a boundary to everything. We generally like to delve into details, and that's how we're manufactured as people.
मैं कभी एक simple-minded lawyer को नहीं मिला.
Simple minded वो पैसे कैसे कमाएगा simple minded होके? ऐसे हो ही नहीं सकता. Simple mindedness से आज तो I mean see there are certain traits that you have to inbuilt as a person to cater to a profession as well.
मैं एक simple-minded marketing director को मिला. आर्टिस्ट को मिला बट एक लॉयर को नहीं मिला.
क्यों मैं हूँ ना सिंपल माइंडेड.
आप है?
बिल्कुल.
I feel that lawyers and cops make very difficult partners in marriage.
You should ask my very recently.
Do they make very difficult partners in marriage?
No, I don't think so. I think that's completely
हमेशा
unfair.
suspicious रहते हैं.
बिल्कुल भी नहीं.
बहुत ज़्यादा analytical.
बिल्कुल भी नहीं.
सुबह breakfast table में बैठ के they start mapping their husband or
Not
wives.
at all. Not at all. My husband is very happy. In fact, he is very happy to have a free fund ka lawyer sitting at home also. Who's taking care of all his legal affairs. And his company affairs, but I don't think so.
You're just 3 months into marriage. इतना जल्दी कैसे बोल रहे हो? Very happy.
We've been together for a very long time. Actually, we've been together for more than 2 years.
And how did you meet him?
We met through a mutual friend. Actually, he owned the gym that I used to go to. One of the many Anytime Fitness gyms in Delhi.
So, what was your criteria of choosing the man of your life? पैसे?
बहुत
knowledge,
difficult decision था वैसे ये.
पैसे,
not
knowledge,
deciding him, but just
पैसे,
deciding.
intellect, looks. अब ये सब इकट्ठा तो नहीं मिलते.
मिल गया है मुझे. बिल्कुल मिला है. And straight out of exactly what I wanted.
Not about you, but generally, you've got friends in your fraternity, don't you?
I don't have many friends in the fraternity.
And why is that so?
I think I'm somebody who needs a breather from the daily chaos that we all live in. And personally speaking, I don't have a great personal wavelength connection with people in this fraternity.
What's the reason?
I think a lot of them are, my experience hasn't been very great.
Why can't lawyers be good friends with lawyers?
I'm
Is
sure
it because
they
of a
can.
sense of competition, jealousy?
No, I don't think so. I think that's a wrong way of putting it.
Kanika, मैं जिससे भी बात करता हूँ outside the legal fraternity, that the perception that lawyers have among people outside is बहुत shrewd होंगे, पैसे के सिवा किसी चीज को नहीं समझते होंगे. Why do lawyers have this negative
ये मुझे भी
image?
नहीं पता है. I have been refused before I got married. When I moved to Delhi, I've been refused 4 houses just because I was a lawyer. I said, मतलब क्या? हम property हड़पने के लिए थोड़ी बैठे हैं यहाँ पे. So it's
वो क्या किस कारण से?
Only because I was an advocate. I got refused 4 houses because I was an advocate.
Because they were worried, apprehensive that कभी अगर शादी नहीं बनी तो.
And I think people generally have this image of you that you're very shrewd in nature because you have a serious profession, but you can be a very pleasant person outside that profession. I always tell people, come have a cup of coffee with me. I'll clear all your misconceptions about lawyers as such.
dancing was one of your favorite pastimes. At some point of time, you wanted to be a professional dancer. Am I right?
Yeah.
So when you joined law, how difficult was it to reconcile the fact that you had to permanently move out of art and performing art?
Yes, I was a trained classical dancer. I've worked with Shamakdawa's company as well. I used to even teach dancing when I was in college, when I was doing law school. But I think there comes a point when you choose either, and the choice was given to me that you choose this or you choose that. You can't do both. Because either of them would have required that time of dedication and effort, right? And I think after having completed law school, after having, done both the things simultaneously, I was more passionate about law. So now
But performing arts is such a fascinating field. When you're dancing to large number of audiences in front of you and people watching you for an hour and a half show, isn't that much more satisfying than cut and dry?
No, I mean, see, I'm a person who loves drama. So dancing is good, but I feel like law is double the drama, once you're working in the fraternity. So it satisfies my requirements for the kind of excitement I look for in life. Dancing was and always will be, a side of me that makes me very happy. But I think I came to a point where I wanted to put all that I had into practice of law and building a business out of it.
Kanika, how beautiful you were as an artist. How come you forgot all of that?
I think it was a very, very beautiful time. It is close to my heart till today. I spent, growing up, I didn't have any siblings, so most of my time was spent playing and learning and dancing with my parents. So it reminds me of Dubai a lot.
How I wish I met the artist Kanika before I met the lawyer Kanika.